I've been in HR for 20 years, and I joined the firm sort of nearly 3 years ago now, having actually been a client and an end user of the HRLI service myself. So I feel like I'm very well placed to speak to anybody about how we can support you and your businesses. If Ingrid, if you don't mind going to the next slide. So we're going to be covering obviously the benefits that you receive from us as a HRLI partner with CECA. I'll be covering that off, and then I'm going to be handing over to Ingrid, who's going to be covering a very good overview about the Employment Rights Bill and everything that's happening at the moment, sort of, kind of hot off the press, essentially. We're also going to be talking about the government roadmap and the timelines that are coming sort of going forward, so that you can plan ahead for what might be coming over the horizon. And as Alison said, please do add any questions to the chat as we go. And then obviously you can contact us afterwards if there's any kind of questions you want to take offline. So if we can go to the next slide, please, Ingrid. That's gone. Yeah, there we go. So just to introduce Weightmans first of all, so we are a full service national law firm. We've got 10 offices across the UK. HRLI is a service that sits within the firm, within the employment, pensions and immigration function. But as we are a full service law firm, we do have the ability to serve any other legal needs that you might have. So one of the things, so Weightmans as a firm, like I said, we've got the 10 offices across the UK. We're very well regionally spread in all the main cities, etc. We can support remotely and also obviously on site if need be. One of the accolades on this slide that I really wanted to draw your attention to, really, in relation to HRLI, is the red one, the top employer accolade. I think this is a really, really important one to sort of highlight to you as your official employment partners. I feel it's really important for our integrity, really, to show that we have actually won that top employer accolade for the 18th year in a row now. And we've been in the top 5 in the last couple of years. I think that really just goes to demonstrate that we do practice what we preach when we're giving advice to our clients and really sort of supporting them. And I think that really kind of demonstrates how we can support our organisations that we're supporting as well. Next slide, please, Ingrid. So in terms of the CECA partnership, we originally became partners with CECA Midlands. That was last year, and then earlier this year that became a national partnership. So we're really pleased to be working with you and rolling out these sessions across the nations and regions. In terms of what we do for you as part of that partnership, you hopefully will have seen we've started to do monthly newsletters that are going out to all members via CECA, and that gives you an update on what's happening in the employment landscape, hopefully some useful content there in terms of possible case law that's relevant and any other information that's useful to you. I'll talk a little bit more in a moment about the exclusive sort of discounted packages that you get as a CECA member, really heavily preferential rates to be able to support you with sort of further support that you might need, which I'll explain a little bit more about in a minute. Member events, obviously, we're doing lots of these sessions at the moment across the nations and regions, both a combination of webinars and in-person events. And obviously, if there are suggestions of any other topics or areas that you would like us to sort of hone in on, please do let us know. Happy to sort of do that, and we'd rather deliver content that you feel is relevant to you. So please do let us know on that. We are doing on kind of a special request, we are doing a session in January that it will be publicised soon on the CIJC terms and conditions, which I know is something that's really specifically relevant to CECA members. So we'll be running that session in Birmingham in January, and once the date's confirmed, we'll get some information out about that. Just to highlight, really, the reason that CECA have decided to partner with us really is one of the main reasons is around our kind of built environment specialist expertise. Weightmans is a large law firm, and we do have specialist lawyers in all different types of services, and really what we're able to do is hone in on those regulatory understanding and the understanding of the marketplace and things like that, and really kind of bring that sector expertise into the advice that we give. And obviously, if the need does grow bigger than the employment offering that we're talking about today, then we can obviously service those needs as well with the wider firm. So if we can go to the next slide, please, Ingrid. Thank you. Just a few things to highlight really about the HRLI service and kind of what we want to be doing with you and work and how we want to be working with you. So we really do want to be a one-stop shop and kind of support you with all your sort of HR and legal needs. One of the things that I experienced as a client that really sort of I feel is a key point really is around the cost certainty. So HRLI, the service is delivered in via a retainer service. So essentially what that means is we're turning the traditional hourly rated model on its head, and able to give you kind of cost certainty back around what you're spending on your employment law or wider legal spend really. I'll take you through sort of some of the packages and how we do that in a bit more detail. But I think, you know, again, from my own client perspective, I felt like nothing was a surprise. I always knew what I was going to be expecting to get on an invoice. And, you know, I think that really built that trusted relationship with Waitmans and HRLI as my employment partner. Flexible support structures. So I'll talk a little bit about the framework of packages that we've got, but realistically, we don't have to stick to that. We really just use it as a framework to guide our clients on kind of how we might be able to support them, but we could scrap it all and create something completely bespoke for you. Our advisors are legally qualified, and that also sort of sets us apart in the marketplace from other providers that provide this kind of support. So our advisors can give you advice on day-to-day HR type issues, such as my employee hasn't turned up to work, all the way through the life cycle of that matter, you know, even to actually doing the advocacy at tribunal. So all of our qualified employment lawyers regularly do advocacy at tribunal, and that really helps to feed the quality of the advice that they're giving on a day-to-day basis. We've already talked a little bit about the sector expertise, so I won't go into that in too much detail. And if we can just go to the next slide, please, Ingrid. So these are just some of the sort of suggestions of matters that we might be able to help you and your business to kind of manage. Obviously, anything that falls under the remit of the Employment Tribunal is really covered by the HRLI service. And anything that isn't is obviously then supported by our wider legal offering from the firm. But hopefully this just gives you a bit of a flavour of the types of situations that we could help you to manage. So really from the front end of the employee life cycle, managing effective recruitment, handling any kind of disputes or matters such as disciplinaries and grievances that come along. Bullying and harassment and employee conflict can be something that becomes really operationally burdensome for an organisation and for a business leader to manage. So this is something that we can really help you to manage effectively, and in the best sort of most efficient and sort of risk managed way as possible, really. Disability is an area which is becoming more and more difficult and prevalent to sort of, you know, to manage. And linked with that is things like managing employee mental health. These are areas which, you know, can be quite daunting when they land on your desk and you're not quite sure how to manage them and how to sort of help that employee. And we can certainly help you to sort of unpick the situation and make sure that we're supporting you with that. Performance issues, again, can be very tricky. And then also the sort of wider things around GDPR, data protection. We're very much seeing a trend now where we have employment tribunal claims that, you know, are put in, and it's the advice that they're getting from their advisors is really to throw in the kitchen sink and become as difficult as possible as a claimant, and therefore it's pretty normal to expect to get a subject access request or a DSAR alongside that employment tribunal claim. So these are things that can be, again, very time consuming, cumbersome to deal with. So we can help with that. And then obviously termination, dismissals, and sort of restructures, business restructures and those sorts of things that you might be thinking about. Then, you know, that's all kind of falls under the support that we can give you. Ingrid, if we can go to the next slide, please. So this is just a little bit about, we did talk about the gold and platinum packages, and I'll sort of go into a little bit more detail about them, but essentially they are the sort of two levels of service that we have in our framework. Gold is aimed at the sort of slightly smaller organisations. And then the platinum is what is our unlimited service. So essentially there's no time limit on how many times you can contact us, and and get support from us. It's all kind of quoted for within the retainer package. So with either package, with all of our support with our clients, we always put together a dedicated team sheet. So you will have named points of contact that would be supporting your business. And that's regardless of how small the business is. We feel that that's the best way to kind of approach things, because we can really get to know you as a client, and we can understand your needs and kind of support you with a really sort of tailored approach. We have a document library also, that's available to all of our clients. Once you become a HRLI client, you can basically get a login and you can self-serve template letters, policies, those sorts of things. Some of our clients want to sort of access that themselves. Some of them ask for their advisors to send them what they need. We can do it both ways, whatever works for you, really. The member events we've talked about, obviously we're doing some that are CECA specific member events, but as a HRLI client, you would then get access to our wider Weightmans and HRLI member events that we run as well. Some of those are in person, some of them are kind of remote over webinars like this. And we would appoint a client relationship manager as the head of that team sheet that would support you with really getting to understand the business, and making sure that the service is what you need it to be to support you. And then obviously being a HRLI client, you would then get access to lots of additional support, such as tribunal support and bolt-on services, which I'll cover off in a bit more detail on the next slide. But all of this would be then available to you at kind of heavily preferential rates. With the platinum service, we do roll in a standard check of contracts of employment and policies. That's not to say that you can't have that with the gold package. You absolutely can. It just means that it would come out of the bulk of hours that you've purchased as part of the package. So that hopefully gives a bit of a flavour of the difference. And if you wanted to talk to me a bit more about this in detail, we can absolutely do that, and sort of put some time in the diary. So if we can go to the next slide. The bolt-on services I talked about are really what sits around the kind of main advisory retainer piece. So these are additional services that might complement the advice that we have, but are sort of priced slightly separately as a bolt-on service. So things like mediation training. One of the really important ones we haven't actually got on this slide is immigration. Business immigration is a really, really tricky area to navigate, and we have specialist immigration lawyers who can help to sort of unpick that. They can help you with obtaining a sponsorship license and managing all of those sorts of things, which obviously with the sort of skills gap in certain areas is really, really important. Investigations, if you end up with something particularly tricky, say for example a sexual harassment type situation, we can parachute in and come in and deal with that for you. All of these bolt-on services, there's many, many more, we can offer you in kind of a really kind of cost sort of square brackets in terms of cost. We can make sure that it's costed as a particular project or a particular piece of activity, and try and sort of frame that around the same way that we do with our HRLI service. So we can go to the next slide, please, Ingrid. So this is really just a guide. We've put this together to kind of help you understand what you might want to start off in terms of having a package with us. These prices are, as I said, sort of really heavily preferential prices for you as CECA members. And we've put this together really just to give you an indication of where you might want to start. The real caveat here is that you might be an employer with only, say, 20 employees, but you may be knowing that you're going through a business change process, or you've got a particular project that you're working on that's employment related, and therefore you might want more than 5 hours. It's really not that prescriptive. It's really just a guide, this framework. So, do have a conversation with us if you're not sure, but hopefully this just gives you a bit of an indication of what it might cost for the sort of levels of packages that we've got. So obviously we've got the 5, 10, 15 hours sort of hours gold package there. And then when we say that the employee gets larger, or you might have more going on, you might want us to quote for our platinum kind of unlimited package as well. So that's there really for your information. We will obviously be sharing these slides so you can have a look at that. But as I said, please do get in contact if you want to have a chat about how we might be able to support you with anything. And at this point, I'll hand over to Ingrid to talk to you about the Employment Rights Bill.
Thank you, Seema, and good morning to you all. Just by way of background, my name's Ingrid McGee. I'm a partner based in Glasgow, and I have specialised in employment legal services and support for, I think, about around 20 years now. So I deal with everything from the contentious, i.e. when we go to tribunal, or advisory or projects, change management, restructures, reorgs are kind of my area, and investigations and the like. So yes, what I'm about to talk to you about this morning is the Employment Rights Bill, and what is it that we actually know. If anyone is interested and has been keeping themselves up to date, they will see that there's been a bit of a game of ping pong between the House of Lords and the House of Commons. They can't agree on how this is all going to come out. It's not yet been agreed. The House of Lords have still knocked back a few things, and it's gone back to the House of Commons. But what I am addressing with you today is kind of a whistle-stop tour around the areas that I think will be important to you and should be on your radar, because some of this is coming through next April, some maybe next October. But again, the fine details, we don't have it all. But I'm happy to give you an indication of where I think it will land, or the likely impact it will have on you all if it goes in the way that Labour first envisaged. So I think that's really important. And again, I always think it's good to have an understanding of this, because it allows you to be prepared now, so that there are no surprises to some extent when this all comes out and we've got further regulations around what the finer details are. So I'm going to touch upon the unfair dismissal proposals, aspects around flexible working, 0 hours, fire and rehire, and family leave. I'm not going to go into detail now because I will during this presentation. And again, collective redundancy, statutory sick pay, fair work agency, family friendly rights, and NDAs. So there are 10 topics there that I'm planning to get through with you all this morning. Like we said, if there are any questions, feel free to put them in the chat and I will do my best to answer them at the end of the presentation. If there's something I don't know, I'm quite happy to admit that. So if I don't know it, I will certainly find out for you at the end of it all and follow up with you when we get when we send over the slides for you. Okay, so the first area of challenge and reform or proposals. Oh, sorry. Thank you. Just one moment. I've got that cup of coffee now. Thank you. The first one is in respect of the unfair dismissal rights and proposals. At the moment, I always say to clients, what we have is a 2-year probationary period, because employees don't have unfair dismissal rights until they have 2 years complete service, and therefore any dismissal, you know, so long as it's not automatically unfair, i.e. discriminatory, related to trade union activity or whistleblowing or public interest disclosures or health and safety, then you're normally fine. Even if you were to bring the employee into a meeting, go, do you know what's not working out, performance is not whatever, or your conduct is whatever, we'll pay you notice, see you later. And you don't have to go through such a rigid process to get through that, to make sure that you have made a reasonable decision. Was it within the range of reasonable responses? But what is being proposed now is that employees will have a day one right to unfair dismissal. So what that means is if on day one you sack them, they will have the right to raise an unfair dismissal claim, which is not something that they currently do. My view on this is far too onerous for certain businesses and businesses of certain size and resource. So what is being proposed as kind of a buffer at the moment is that there will be an initial period of employment. So effectively, there will be a kind of probationary period of around 9 months where there will be a lighter touch process that employers can follow to effect what would be considered a fair dismissal. But to me, if anyone on the call this morning remembers the dispute resolution procedures. I can't remember how many years ago. It was very prescriptive. You know, the letter had to be in a particular way. What was in it was important. The process would be, and you could have what we called a procedurally unfair dismissal. And I feel we're slowly moving back to that, but not necessarily in a positive way for certain businesses. And it might be that there'll be a less compensation that could be awarded. So my view is that there's going to be almost like a two-tier set of unfair dismissal rights and claims, compensation and procedures that businesses will need to grapple. Where this is sitting at the moment is the House of Lords are really intent on trying to build in a 6-month period of continuous service that's required before you get unfair dismissal rights. And that's a far cry from the 2 years we currently have, but at least it's something. But then they wouldn't have to provide new legislation. They could just amend that from the 2 years through statutory instruments. It wouldn't have to go through a full process. But my view is that because Labour put this forward as part of their manifesto and the proposals, they're not really looking to back down. So if this does go ahead, it's likely to come into play around 2027, but there's still a bit of, as we say up in Scotland, jiggery-pokery up here, just in case there might be a bit of a change. So we'll see what happens. We'll keep you updated. But again, what will be important is that you have an internal probationary period process. You have it built into your contracts so that you're very clear contractually what you're entitled to do as well as legally. And again, I just think it's going to be very onerous. But again, that's what's proposed. It's not final yet, and we'll just have to wait and see what happens. Now, with regards to flexible working, the current regime is that employees have the right to make a request or to put in an application to flexibly work. It is not the right to flexibly work. There is a very important and clear distinction between that. But what we are seeing being proposed is that whilst at the moment businesses can refuse an application based on the statutory grounds, what is being added here as part of a process will be whether or not the refusal is reasonable. So there's never been a huge amount of focus on the reasonableness, albeit, if I'm being honest, when I advise clients around refusing flexible working, I want that sense of reasonableness. I want to test their theory. And I usually say to businesses, why can't you do it? Just because they say it's not been practiced, it's not happened in the past, we've always done it this way, usual standard responses that I can sometimes get from clients. I will say, imagine I don't care. If the tribunal say, why can't you implement it? What have you got to back that decision up? So I feel that when I advise already, I kind of try and get the business or my clients to think about that. But the law will change to require businesses to be more on it. So it's not enough to just have a statutory ground, which is usually detrimental impact on the department, cost and resources, detrimental impact on service delivered to clients. Those statutory grounds, some businesses can be quite lazy and go, well, that applies. That's why we're not going to do it. That's not going to be sufficient. We are now going to have the element of reasonableness, which is it reasonable to say that that is the case? So I think that what will be important here are trial periods. Now, you can have trial periods now, but I can't see why a trial period won't be necessary going forward. And I say this because in order to demonstrate reasonableness, my challenge, if I was acting on behalf of an employee, would be, well, how do you know? How do you know it's not going to work? Have you given it a go? Have you tried it before? And if you haven't, you know, I would argue, then are you being reasonable? So on that basis, I would be recommending to clients, as I do now, is to implement a trial period, but make it very clear, written terms that say your request for flexible working has been refused. However, we are willing to trial it for, say, 3 months, maybe 6 at a push. If it works and if it's suitable, and understand what the parameters of what is suitable or what works for you as a business is, if it works, it would be a permanent change. If it doesn't, we make it very clear that you revert back to your original working patterns or pre-flexible working request made. So that letter or that communication is going to be absolutely key. So that's something to be bearing in mind. And also, I would also look at your current working parameters, your departments. How is that made up? If someone were to say, I want to work part-time, I want a job share, I want to do compressed hours, why are you not thinking about this now? Would it work for you? If not, why not? Have a bit of groundwork. I've got a client at the moment that's done this exercise really well, actually. And they've gone through each department and each kind of role and said why certain things would or would not work. And I've said that's a really great framework and platform to evaluate a flexible working request, but don't be stuck to it. Don't be rigid in your application of it, because a employment tribunal would still require you to demonstrate discretion and flexibility in your thought process. So if you were just to point to a matrix, it just wouldn't work. I think you can say, you can point to a matrix, this is what we think it is. It gives you a basis for maybe refusing, but you need to delve a bit deeper there, in my view. So I think that's probably all I've got to say around flexible work requests. The one thing I will add to it, though, is that when this goes wrong during the application process, which is usually when an employee doesn't feel heard, doesn't feel that their request is being considered properly and reasonably, then they are likely to raise claims around that. And also with flexible working requests, it's a really big risk area for businesses for indirect sex discrimination claims. And I say that because at the moment, it's still the position, albeit there is some improvement, but it's still the position that women work part-time more or have the caring responsibilities of the family, home and children more so than men at the moment. So if you refuse flexible working, which is usually required to help with childcare, that refusal or could be said to be a provision, criterion or practice that you adopt that has more of an impact on women than it does men. So that gets your indirect sex discrimination claim in there. And secondly, you need to be able to say, well, okay, it might have that effect, but you know what, it was proportionate, it can be objectively justified. And what that means is that, have you got a legitimate aim? What is that? Most businesses do, but is that proportionate? And that's where most businesses fail, because it can say we can't have that because it's not good for our business, it's not good for clients, whatever the reason may be. So that's your legitimate aim. You're trying to protect something business wise, but is it proportionate? That's where most employers fail on that test, and that's where an indirect sex discrimination claim can succeed. So I think that's all. I said that's all I wanted to say about that, and then I carried on speaking for another 2 minutes. So I think that is all I'm going to say about that. So the next one is around 0 hours and low hours. I can't see everyone on the screen. I'm going to see if I can do something that can. So can't see everyone, but I don't know if I can see if there's a show of hands or whether or not a number of you as a business actually operate low hours or 0 hours. So I think the purpose of this was to kind of get rid of exploitative practices. We saw that, Mr. Ashley's of the world, where, they wouldn't guarantee hours for workers, when in reality, they were working regularly every week and the same kind of hours, same kind of days. So I get that, but I don't think that many businesses still operate any kind of exploitative contracts or practices. There might still be some, but I'm not aware of it being a widespread issue that remains in the UK. But the purpose of this, and the reason why it's not being supported by the House of Lords at the moment, is that it is going to require businesses every 12 weeks to offer guaranteed hours by having a look at what the individual has worked in a 12-week period. Now that employee may go, or that worker may go, no, it's okay, I don't want it. But then the business has still got to say, next 12 weeks, do you still want this? And next 12 weeks, do you still want this? That's really onerous on businesses. And what the House of Lords are saying, well, can you not get it so that it's the employee that has to, or the worker that has to ask for it and go, can I have these guaranteed? I've had this for this pattern for the last 12 weeks. I'd like it to be guaranteed. So there's a bit of toing and froing on this particular issue between both houses. The other area I'd probably highlight is that we've not got low hours defined in any way. So it's very clear when someone works a 0 hours contract, but what's low hours? I was speaking to colleagues yesterday. We think it might be something under 10 or something under 15 hours a week. I don't know. It's definitely part-time of some sort, but again, you can see why it would be quite onerous. And the other thing we were thinking about, because obviously we're trying to always think of solutions, is that could you get an employee to sign away their right, if it's going to be a right, to say, I don't need you to ask me every 12 weeks. If I change my mind, I'll let you know. But at the moment, because we've got to also remember that those that work on 0 low hours contracts are probably quite happy with it. Maybe it gives them the flexibility they need. It's seasonal, it could be anything. But I think there's been an assumption made that all employees working under this kind of regime want something guaranteed, and that's not always the case. So yeah, that's all I'd say about that. So fire and rehire. This is, in my opinion, I feel like I need to always say that when I'm about to go off on one. This, bizarrely, isn't getting too much resistance from the House of Lords, but this is one of the proposals that I've got a real issue with for my clients. So I don't know how many of you on today will have gone through a fire and rehire practice, but I often advise businesses around fire and rehire, but it's not like whimsical. It's not just use it as and when. It's not the default setting. What it is that when we try and consult and inform employees about proposed changes and why things need to be changed, and we do that all properly, and you still get a fraction of the workforce that go, no, not doing it, when everyone else has, and everyone has played ball, everyone gets it, and everyone said, you know what, for the greater good, that's fine. You've got a fraction that might say, I'm just going to dig their heels in and not going to do anything about it. And for those individuals, when you feel like you've done everything possible, reasonable, to kind of bring them along on the journey with you, and it's necessary to make these changes, and this is why it helps, you've explained all of that, you said when it's going to be implemented, and they still don't agree, at that point you might want to think, well, do you know what, this is a dismissal for some other substantial reason, because you're not willing to agree the changes that we need to make. You can't push them forward unilaterally, because that would be a breach of contract. So what you have to do then is dismiss the employee and immediately offer them the new contract and say, well, this is what you can do, this is what you can sign up to. And the employee then can raise an unfair dismissal claim. But my view is, if you've gone through a process, you've got sound business reasons for doing this, and it's an SOSR, others have agreed, you don't, and you've offered a brand new role, you know, with certain changes, I think that's a really good system. That's my view, if an employer does that properly. Now, under the proposals, you're not going to be allowed to do that anymore. Fire and rehire is going to be an automatically unfair dismissal unless businesses can demonstrate that they are in financial difficulty. And this is not financial difficulty down the line and they're, you know, forecasting. This is like imminent, immediate. And that's just not how businesses work. This almost feeds into a narrative that businesses are reactive, whereas most businesses, or successful and proper businesses, do forecasting, and they want to see what the next 3, 5, 10-year plan is. So if you think you want a leaner workforce, you need to make changes. You'd implement those changes now to make sure you're in a better position in years to come. And this doesn't allow businesses or employers to do that. And if you look at the bullet points, these ones, I don't know if you can see 2, 3, 4, here, these 3. So they're saying here that dismissal will be automatically unfair if the employee refuses to agree to a restricted variation of the contract, which is what most businesses use it. I want to change maybe the days you work, but we'll taper it, or I want to change maybe a benefit, or I want to add restrictive covenants, or whatever it could be. A contractual term needs change, and we want to do the right thing, consult with you about it before we do that. You can't do that. To enable the employer to employ another person or to re-engage the employee in the same role, that's a fire and rehire that I said as well, in terms of fire them but rehire them. And the third one is what I call the P&O example, which is when we said we want to sack everyone that we currently use and we're going to subcontract the work. We're going to use a different workforce makeup. Okay, so again, within business realms, you can understand why you might want to make those decisions and have that kind of structure. But under this proposal, you're not going to be allowed to do that. So again, that's an issue in my view. The other thing is that when you make dismissals of 20 employees or more within a 90-day period, there is a prescriptive process that businesses have to go through that involves is labelled collective consultation. And if businesses get that wrong, for each impacted or affected employee, they can claim up to 90 days gross pay for whatever the business did wrong as part of the process. And again, the government are proposing that that's going to be increased to 180 days. So what does that tell me to tell you? That's going to be expensive if you get that wrong. Make sure you get legal advice when you are going through a collective consultation process. Make sure if you have an HR department or anyone that deals with HR is very clear of what a collective consultation process is, because to pay out up to 180 days gross pay for each employee, it's huge, very significant. So again, it's not something to not take seriously. So that's what I'll probably say about that. Quite passionate about that one because it works for our clients, it works for the businesses that I deal with, and it makes sense as long as you're sensible and reasonable with it. I get it if individuals like are exploiting it. P&O was a really bad example of just, not really caring. It was quite insensitive. It was a really huge PR mistake in my view. But ultimately, if I want to give a balance view, is that yes, they dealt with that poorly, but every employee that was impacted got paid what they would have been paid had they been successful at an employment tribunal. So they just took the decision, we'll pay that and we'll just move to this model. Crass, perhaps, immoral, perhaps, but again, it's something that some businesses do, but not many. Many do it right and use this properly. Just conscious of my time, so I'm going to have to move on quickly. Collective redundancies. Again, I just gave you a definition of what that is. So when 20 or more employees are being dismissed or made redundant within a 90-day period, you've got to follow collective consultation. The issue with what's being proposed here is that at the moment, and if you've got a number of sites, you would understand, are you making 20 or more employees redundant on that site? That's a well-established principle. But what's being proposed is it's widening that net. It could be 20 or more within the business. So if you've got a number of sites and you're making 1 or 2 redundant in a variety of sites, you could hit that 20 employee threshold very quickly and have to be forced to go through collective consultation. So there's been a bit of pushback around that. So what they are now including is that there could also be, so it might be 20 or more employees at one establishment, or it could be a threshold number of employees. So we think that the government might implement, say, if you're looking to dismiss or make redundant, maybe say 10% of your overall workforce, then collective consultation might be triggered. But again, that's still subject to consultation at the moment, not likely to come in until 2027. But that's going to be a problem for businesses who have multi-site locations or regions that could be impacted by this, because the collective consultation regime is prescriptive, based in statute, and it's onerous. You have to follow it, and usually provides for either dealing with the trade unions or going through an election process for elected representatives. This one won't take long. This is statutory sick pay. It's coming in April. Basically, businesses now won't be afforded the gap of the 3-day wait. So when employees are off sick, they don't get SSP within the first 3 days. It goes on from day 4. That's changing in April, so they will get it from day 1. It is removing the lower earnings limit. So I think 1.3 million employees currently earn below the lower earnings limit. And again, so they're now within this band. And again, it's increasing to £118.75 a week. And again, just generally, it's an increased burden. I already know a number of clients are already factoring this in. They're looking at, kind of what sickness levels are, how this would impact. So again, they're forecasting what this could cost them in years to come. So again, if you've not done that, I would recommend you do that as well, so you kind of know what that financial hit is likely to look like next year. So the Fair Work Agency, this is going to be a new enforcement structure for the labour market legislation. And again, it's an enforcement body. And again, what they will look to enforce are things like when businesses aren't paying national minimum wage, statutory sick pay, holiday pay. And for example, if you were to settle a claim under a cut-through agreement for employment tribunals, that it would be covered under that. It is aimed at supporting workers and good employers and punish bad ones. That's what we put up there. But again, the plan is quite unclear. And what I will say about this is that if it's anything like the ICO, which is a great function, and a great body, but anyone that deals with the ICO will also know they are hugely underfunded and under-resourced. So the impact might not be as strong as one might hope or think might come about. So that could be the same for the Fair Worker Agency. What I will say about this as well is that the Fair Worker Agency will also be able to raise claims in their own right. So, for example, if a number of employees happen to go to the FWA and say, look, we think there's an issue around SSP or holiday pay or national minimum wage, and they get an inkling that there is something, there is nothing to stop the Fair Worker Agency raising a claim against a business for that reason. So again, that's something to be mindful of. Again, so we think it's going to be established in 2026, but again, in terms of their enforcement powers, we don't know when that's likely to happen. But again, definitely worth being on your radar. I'm not going to go into too much detail around family-friendly rights, but you do need to be aware that they are all coming into play. I think some of these are coming in next April and some are next April 20. So I'm just going to have a double check my notes. Yeah, some of this is 2027. I can give you more detail about what they are, but I think the main thing to understand is that normally with a number of these rights, an employee has to have 26 weeks continuous service before they get the right to things like maternity pay, paternity leave, unpaid parental leave. That's been scrapped and it's going to be a day one right. Again, in terms of bereavement leave, it's going to be extended to a wider group. So that could be individuals, and it's again with miscarriage leave, those that had miscarriages. Again, the wider group we don't know, it's not been defined yet, but at the moment you get bereavement leave. I think it's around 2 weeks leave and pay. So the main thing around that is you need to be aware of what these rights are, what the entitlements are, update your policies and your procedures to be in line with the legislation when it comes out, because there is quite a bit, and also there's a cost factor to this. The fact that you don't now have the 26 weeks continuous service requirement. The other thing that I've not mentioned there is the one at the top, the additional protection against dismissals for returners from maternity leave. So at the moment, if someone who's been on adoption leave or parental leave or maternity leave, from the date of birth or the date of placement of the child for an 18-month period, they get priority if they are in a redundancy situation for any suitable alternative vacancies, not alternative roles, but suitable alternative vacancies. So that was something that was extended earlier this year or last year. But what's being proposed now is that individuals who return from maternity leave, it will be automatically unfair to dismiss them within a 6-month period when they come back from mat leave. Now, again, I don't have the finer detail, but I would imagine it's accepted that someone who's been out of business for a considerable period of time, maybe their performance isn't up to something, then again, to go into a performance management process and to kind of deal with that, not right and unfair. Redundancy, not sure, because if there's a legitimate reason, i.e. they haven't, that role will no longer exist, you could understand, well, why would you just, circle an individual that's come back from maternity leave when there is no role, or when you have the suitable alternative vacancy protection. But again, don't know if that's going to apply to redundancies. I don't see how it could apply to, say, for example, if they were guilty of an act of gross misconduct. I can't see how that would apply. But again, we don't have the finer details around what that additional protection is, but I can understand why it's being put in place, because someone, it could be on maternity leave, but it could also apply, we don't know yet, to shared parental leave, adoption leave, how it might apply, because they're out the business for a considerable period of time, and then to be faced with kind of a dismissal process seems a bit unfair in the grand scheme of things. But again, finer detail will be absolutely key for that one. Non-disclosure agreements. So at the moment, we are already prohibited from using NDAs to prevent employees from making a protected disclosure. Okay, so protected disclosures could be anything in respect of where there's a public interest and it relates to maybe health and safety, breach of legal obligation. Okay, so that currently exists, but what's being made clear is that sexual harassment will be covered under the whistleblowing or the protected disclosure legislation. So again, I was having a chat with my colleagues about this a couple of days ago, because ultimately when businesses look to settle a claim, which could be in relation to sexual harassment, you kind of want it. Most businesses want to know that's it done, that the employee's not going to raise any issues about it. They're not going to raise it in a public forum, and they're not going to talk about it anymore. That's not going to be permitted anymore. So I do wonder how my clients will react to when I say pay them whatever to settle some of this claim, but actually they can still go to the press, they can still go put something on social media, they can still. So I don't know how that will land. And also there is suggestion that it might not work both ways, because an employee might say, do you know what, I don't want anyone to talk about this. I don't want this raising its head again, and that's fine. But I don't think it's going to be permissible for the employer to dictate that. Don't know how it's going to reenact in practice, but again, something to be aware of, because it might have a bearing on how businesses approach maybe settlement discussions or employment tribunal claims. So in terms of what's next, so the bill will return to the House of Commons for further deliberation. Again, only once it's agreed by both the House of Commons and House of Lords will it receive royal assent. So we're not there yet. It's gone back to the Commons. There are consultations around trade union measures, dismissal and re-engagement, and some umbrella company bereavement leave, all of that's listed there. What I would say, I've not touched upon trade union activity, but there is going to be, there's been a lot of consultation around what's been proposed, because you're going to have to give access rights to the trade unions. It's not clear whether or not they have to be recognised or not. How often there's a suggestion that weekly access, which again has been pushed back by saying that's crazy, that's too onerous for businesses. So again, there's a lot of activity and discussion around the trade union points. The other thing is, sorry, sorry, 2 seconds. Yes, sorry. The other thing around trade union activity is that some businesses don't currently recognise unions within built environment, within construction. I think there usually are unions, but if not, some businesses are considering whether or not they would look to voluntarily recognise rather than have it forced upon them through CAC. So again, that's something that some businesses are dealing with at the moment. And again, consultation on what will amount to reasonable steps to prevent workplace sexual harassment, which is expected in 2026 and 2027. So I think that's me. I appreciate that's been a bit of a brain dump, a bit of my opinion on it as well, which I think I've been fairly measured with this morning. But if there are any questions, more than happy to deal with them. And just want to say thank you for your time this morning. I know we're all busy individuals, but I think it's good for you to spend a portion of your day just kind of understanding maybe where we are with it all and what's on the horizon. So thank you.